All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw an eye and give their attention to the court, now sitting.
Please be seated. Good morning and welcome to the Kansas Supreme Court. For those of you watching through our live stream, we have a very full courtroom this morning. Almost every seat is full. We're very happy to have so many students and their sponsors and parents and others accompanying them with us today. We appreciate this opportunity to help hopefully expose you to how the Kansas Supreme Court works, explain some of those processes, and increase your understanding really of how what the role of an appellate court, which of course is something that you don't really get to see. Our jobs are a little too boring for that sitcom on TV or any other sorts of mass media kind of coverage of what we do really in terms of how we function or any of that. So here is a chance for a glimpse of what we're doing. I would like to recognize each of the student groups that are with us today. So I will ask a sponsor, an adult sponsor, to please come forward and introduce your group and tell you where you're from and the program that you're with. I will start with Professor Rollader-Suk, who's in the middle of the aisle. I'm sorry, but if you'd like to come to the lectern, please, and introduce yourself and your students.
May it please the court. My name is Wendy Rollader-Suk, and I'm an assistant professor of political science at Fort Hays State University in Hays, Kansas. I am pleased to accompany 3 students today, Joanna Carrillo Maldonado, Jackson Sinsel, and Morgan Lane on our visit today. Thank you.
Welcome to all of you. Hopefully prospective attorneys, we do a pitch that we do need you in our profession. So please consider joining us there. And that's true for all of you. Then Sunflower School. Ratzlaff.
May it please the court. I'm Chris Ratzlaff. We are with Sunflower School, which is a private school in central Kansas, McPherson County, Kansas. And we have the 7th and 8th grade here together with their parents. Thank you.
Thank you. And again, welcome to all of you. And then Sugar Creek Private School. Well.
May it please the court, I'm Craig Weedle from Sugar Creek School, and we are here with grades 6, 7, and 8 and their parents, and we are also from between Saline and Wichita, Galva, Kansas.
Okay, so my husband is a native of Galva, so you can actually say Galva and I know where you are.
It's a privilege to be here.
Yes, nice to have all of you. Nice to have you from our from kind of home country, so that's wonderful. Well, again, welcome. We'll talk a little bit about procedures as we walk through to hopefully help you understand some of the things that we are doing today. And at this time, I would like to ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 9 a.m. docket.
Thank you.
First case on the 9 a.m. docket for Thursday, March 28th, 2024 is appeal number 124861, State of Kansas versus Christopher Michael Jacobson, Johnson County, briefs both sides.
Madam Chief Justice, and may it please the court, petitioner appellee excuse me, State of Kansas appears by Assistant District Attorney Daniel Liebermeyer, present and ready for argument.
Oh, it throws us when you're on that side of the room too.
May it please the court, Emily Brandt of the Appellate Defender Office. I'm proud Fort Hays grad. Here today on behalf of Mr. Christopher Jacobson, who appears in person and through counsel, present and ready for argument.
Second case is appeal number 124314, State of Kansas versus Joshua Evan Stowe, Shawnee County, briefs both sides.
Good morning, your honors, and may it please the court. Kai Mann of the Appellate Defender Office on behalf of the appellant Joshua Stowe. And may I please request 3 minutes for rebuttal?
3 minutes is reserved.
Thank you, your honor.
Good morning, may it please the court. The state appears by Deputy District Attorney Jody Litvin, present, ready for argument.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. If counsel in 124861 State versus Jacobson would like to come forward. While they're coming up and getting settled, I'll explain a little bit about, before we have come to the courtroom today, the court has received briefs and arguments from the parties. We have, both of the cases that we will be hearing today have made their way through a district court, a trial court, with an appeal then to the Court of Appeals, which if you haven't toured the building yet, you may be, and you will find that they are housed on the second floor of this building. They are an intermediate appellate court. From there, the parties, in this situation, the state had reasons that it didn't want to accept the decision of the Court of Appeals. So they have the right to petition this court for us to grant, in our discretion, review of that case. We see somewhere between 700 and 1,200 petitions for review a year. We obviously can't take all of those. So we have criteria we usually use. Often it is that it's a legal issue that is likely to be repeated. So we are providing guidance to all courts about that issue. It could be, the Court of Appeals sets in panels of 3. Occasionally, those panels will disagree with each other on a point of law. And so we will take the case to resolve the disagreement. And there are other reasons as well. But we do have all of the paperwork and the briefing that has come before us in addition to our own research. So as we do go through this process, you may see us looking at either computers or papers that we may have in front of us as we refresh ourselves about some of the arguments that were made, some of the legal authorities that are being cited. Please know that as we do that, we are doing it not because we're distracted from the argument, but because we are trying to focus on the fine detail of the argument and better help us understand what the attorneys are arguing. With that, Mr. Obermeyer, if you would like to come to the lectern, we'll begin.
Madam Chief Justice, and may it please the court. Petitioner appellee, State of Kansas, appears by Assistant District Attorney Daniel Obermeyer. Madam Chief Justice, I would ask the court reserve 5 minutes for rebuttal, please.
5 minutes is reserved.
Thank you, Your Honor. The issue which this court is dealing with today is to what extent Wettrick is still effective. I'll begin by laying out some of the legal history for the benefit of those present here. So I'll just try to oversimplify that maybe a little bit, but hopefully get to the essence of what this court has previously held and why that's important. And then I'll address its application to the case at hand. As the court knows, Kansas has a sentencing grid which determines a presumptive sentence which every criminal defendant faces as potential punishment. And to determine that potential punishment, we look at the severity level of the offense and the criminal history, which is dictated by person and non-person felonies. To determine whether something is a person or non-person felony for a Kansas offense is a simple matter. The legislature has designated whether or not it will be a person or non-person felony. For out-of-state offenses, there is a lengthy history as to whether or not an out-of-state offense will be counted as a person or non-person felony for purposes of the Kansas sentencing guidelines. Importantly, this court has held in State v. Vandervoort, the law which was in effect at the time the defendant was sentenced back in 2015, that in order to determine whether or not an out-of-state offense should be counted as a person felony, the sentencing court is to look at the closest approximation of that out-of-state offense to a Kansas offense. If there is no closest approximation, then that shall be scored as a non-person felony, which lowers the potential range of punishment a criminal defendant faces. That was the law of the land up until State v. Wettrick, which was decided on March 9th, 2018. State v. Wettrick held that the closest approximation test was no longer the law in the state of Kansas. Instead, in order to determine whether or not an out-of-state offense should be a person felony, the out-of-state offense had to have elements which were identical to or narrower than a comparable Kansas offense. If the elements were broader than the Kansas offense, then it was to be counted as a non-person felony. The effect of this in many criminal cases was that criminal histories for many criminal defendants were reduced significantly, as what were previous person felonies under the Vandervoort test now became non-person felonies under Wettrick. That, by way of background, is the law up until June 27th, 2019, when the legislature overruled Wettrick, and subsequent decisions by this court have clarified that while a defendant is entitled to a change in the law during the pendency of an appeal, that otherwise the law in effect at the time a defendant is sentenced is the controlling law, and a legal sentence cannot later be rendered illegal by a subsequent change in the law. The court has also subsequently held that Wettrick is such a change in the law.
Just to clarify, that's an appeal from a judgment of conviction, correct? The statute, as opposed to any appeal? Or do you have a view on what the statute provides?
The way I read the statute is that we're talking about a direct appeal. So this is after a case is either pled or tried, and then the defendant is subsequently sentenced. And that then goes through the normal appellate process, either to the Court of Appeals or to this court. And while that case is pending, the way I read that case law, or the way I understand it, is that if there's a subsequent change in the law, the defendant will get the benefit of the change in the law during that appeal. To go to this case, the defendant was sentenced in May 2015, and he was sentenced. He did not take a direct appeal. He did not challenge his sentence at that time. Subsequently, he filed a motion to correct an illegal sentence in June 28, 2019. And that challenged his Missouri municipal convictions, which are not at issue today. But the ultimate effect of that was he took an appeal. The state essentially agreed that these should not be counted, and his criminal sentence was reduced. His history going from an A with 3 person felonies to a B with 2 person felonies. Those person felonies were Missouri attempted robbery convictions. Now, while he was being resentenced on that, the defendant challenged those Missouri robbery convictions. And it's an interesting argument. If the court reads this in volume 14 of the record, it seems my reading of it is that the parties agreed that the proper test for the district court to apply was Vandervoort. And to get down to the essential detail of this case, if Vandervoort is applicable, then his convictions are properly classified as person felonies. If Wettrick applies, they should be non-person felonies. I think that's clear to the parties and this court as well. The district court found that Vandervoort did apply and affirmed those convictions as person felonies. The defendant took an appeal to the Court of Appeals, which held that the defendant was entitled to the benefit of Wettrick. The state filed its petition for review in that matter, and we're now here before the court. The state's position is that State v. Clark 2021 case effectively barred the Court of Appeals from doing what it did and giving the defendant the benefit of Wettrick.
The Court of Appeals thought Clark was distinguishable. Would you address why that's presumably wrong from your point of view?
My reading of the Court of Appeals is that Clark was distinguishable because there was no illegal aspect of his sentence. And in this case, the defendant did have an illegal aspect of his sentence, which was the Missouri misdemeanor convictions, which the state ultimately agreed shouldn't be counted against his criminal history. I think this case is distinguishable because the Missouri robberies, attempted robberies, that was not an illegal aspect of his sentence. Those were under the law at the time he was originally sentenced, the closest approximation to Kansas robbery, so it was properly categorized as a person felony. The edge which the defendant is trying to get in this case is that, well, if any aspect of the sentence is illegal, then any other aspect can later be challenged. And that is just that's sort of a roundabout way of getting a motion to correct an illegal sentence in.
It doesn't, don't all proceedings arise from the filing of a motion for a legal sentence? Aren't we just still in that course of procedures that come from that vehicle? And doesn't Clark say that matters that rise from a motion to correct a legal sentence sets those rules? Clark doesn't really make the distinction about whether or not the second sentencing might be legal or illegal, does it?
And that's one of the things to which I think this important for the court to clarify today, just to what extent Wettrich is alive, and it does have effect. The important thing here is that when the defendant was sentenced in 2015, there was no direct appeal taken at that time in his sentence. The Wettrich didn't apply his original sentencing. And then when he filed his motion to correct an illegal sentence, even back in June of 2019, Wettrich had been overruled legislatively, and then subsequent rulings from this court held that it's a change in the law that doesn't apply retroactively. So it wouldn't apply at that stage either. So if it doesn't apply at those two stages, there's no reason why it would apply on appeal. And Clark also.
Can I clarifying question? What was the status of the law when he was resentenced?
The status of the law when he was resentenced in 2022, Clark was the last word which the court had guiding it. And I think that that's significant because the parties were under the impression that Vandervoort was controlling the law.
I'm sorry, just walk me through, when was he resentenced?
I don't have the precise date, but it was in June of 2022. Or I'm sorry, in 2022.
So he files his motion in 2019, but doesn't get resentenced until 2022. Is that right?
That's correct. But that original motion to correct an illegal sentence, that addressed the Missouri municipal convictions. They did not address his Missouri robbery convictions. He subsequently filed two other motions to correct an illegal sentence.
So it worked its way through the appellate process, went back to the district court in 2022. And so he filed the motion to correct that we're currently hearing isn't the 2019 motion.
That's correct.
It's okay. Thank you. That helps me. Sorry.
No, thank you, Justice Stiegel. Your Honors, I see that I am out of time for my opening portion, unless there are any questions. Thank you.
May it please the court. I want to address a couple of things. First, the Court of Appeals did find that Clark this case is distinguishable from Clark. I believe that the Court of Appeals is correct in that regard. This is not like Sidney Clark's case. This is not like Charles Moore's case. This is not like a Murdoch case. When Chris was sentenced in 2015, as the parties agree, his sentence was illegal, as pronounced under the law in 2015. Regardless of whether Vandervoort applied, Wettrich applied, his 2015 sentence was illegal.
What made it illegal? Is it the inclusion of the municipal court convictions, or what aspect made it illegal?
Yes, the inclusion of those 7 Missouri municipal violations, which aggregated into 2-person felonies in 2017, should never have been scored.
But what about at the time of his original sentencing? Was it attempted aggravated the robbery convictions? Those were correctly scored, weren't they?
We haven't made any arguments in this briefing about whether or not those were correctly scored under Vandervoort. Because I don't actually think that that's relevant, because Mr. Jacobson's sentence didn't become illegal because of some change in the law, like in Clark and Murdoch and Charles Moore's case. His sentence was illegal when pronounced. So we're not saying that Clark should be overturned or that Clark is wrong. We agree that the legality of a sentence is determined based on the law in effect at the time of sentencing. And based on the law in effect at the time of sentencing, Mr. Jacobson's sentence was illegal. So his sentence was necessarily vacated and he was necessarily resentenced in 2022. And in 2022, Wettrick ruled the comparability analysis of out-of-state offenses. He had to get a new PSI. They had to recalculate. And in 2022, Wettrick was the law of the land for Mr. Chris Jacobson. It should have applied, and the Court of Appeals correctly held that it did.
Let me ask you a question. So if we drill it down, the issue here is, to me, and you can correct me if I'm wrong, that is this a direct appeal or an appeal from a denial of a motion to correct an illegal sentence? Those are two separate things. And do you get the benefit regardless, right?
Mm-hmm.
Okay. So when you look at the statute, the plain language of the statute, 223504, which was amended in 2019, when you look at subsection C2, change in the law means a statutory change by an appellate court, unless the opinion is issued while the sentence is pending an appeal from a judgment of conviction, not an appeal from an illegal sentence, but from a judgment of conviction. How do you respond to that?
Yes, Your Honor. So I think two parts here. So is it a direct appeal, or are we sort of in the same train as this motion to correct an illegal sentence that was filed in 2019? Our position is this is a direct appeal, right? Because when his sentence was pronounced, it was illegal, it was vacated, he had to necessarily be resentenced.
But it's not, would you agree it's not an appeal from a judgment of conviction?
Right, this is now an appeal from a judgment of an illegal sentence.
Right.
Which, I mean, to be fair, Your Honor, if a client is convicted and they get a presumptive sentence, or we think something is illegal in the sentence, we can file appeals that are direct appeals without challenging our client's convictions, but challenging that the sentence is illegal as pronounced. And that would be considered a direct appeal, even though we're not challenging our client's convictions. We are just taking an appeal from the sentence.
Right, but there are time limits for a direct appeal, correct?
That's correct, Your Honor.
Was this filed within the time limit of the?
Well, our position would be that it was a timely direct appeal of the resentencing. It would not be timely.
No, but I'm talking
Yes.
about the motion to correct a legal sentence, which was filed in 2022 on this issue. Was that timely filed within 14 days of judgment?
Our position would be yes, because we think the judgment comes from,
Judgment of conviction.
right. But our position though is that
When was he convicted?
in 2015.
Thank you.
But to your second question, Your Honor, which is, do I think Mr. Jacobson gets the benefit regardless? My position is that he does. Again, his sentence didn't become illegal because of a change in the law. Wettrick didn't come down during the pendency of his appeal. But when he was resentenced in 2022, Wettrick was the law of the land. Vandervoort was no longer the law of comparability. You have to use the comparability analysis or the statute that was in effect at the time of his offense, which says that to score a person felony, the out-of-state conviction needs to be comparable to a Kansas conviction. So that's the statute we're looking at. And the comparability analysis in effect in 2022 is Wettrick. So I think that regardless of how we get there, Mr. Jacobson gets the benefit of Wettrick in 2022.
Isn't the point of Clark, though, to identify a discrete set moment in time in which we'll analyze the legal framework? And as I read Clark, it suggested to me that that discrete point of time is when the original sentence was imposed. So, I mean, I'm not seeing the distinction other than the legality versus illegality of the original sentence, but procedurally, otherwise, it's pretty similar to Clark. it appears to me. And it seemed to me that one of the major takeaways of Clark was to kind of pin that point in time. And as I read it, it seems to me that that's the original point of sentencing. When the original sentence is pronounced, regardless of its legality or illegality. And tell me where we might be wrong or your view on that.
So our view on it, right, again, we don't disagree that the legality of a sentence is determined based on the law in effect at the time of sentencing. But we think that once the legality is either determined or found illegal, then we are no longer pinned down by that discrete moment in time. We're not here today to talk about whether or not his 2015 sentence was illegal. It was illegal.
I'm sorry to interrupt, but it sounds like you're saying the original sentencing date is 2022.
That's correct. Yeah, that's our position, is that the original sentencing date is 2022.
So we could apply Clark and you could still prevail.
Yes, yeah.
From your
yes,
perspective.
Yes, from my perspective, regardless of you think this is a direct appeal or something else, Mr. Jacobson prevails, because we determined at the discrete moment in time in 2015 when he was sentenced, we determined, the parties all agreed, his sentence was illegal. So he was,
Wasn't that the same argument made in Clark though, however, that they were trying to pin it to the time where the illegal sentence was corrected and resentencing from that, or that's the relief that they requested, as opposed to the original date of the sentence pronouncement.
right, but in Clark's case, in 2005, when he was sentenced, based on the law in effect in 2005, Mr. Clark received a legal sentence. So he doesn't get any benefits. There's no change in the law that helps him out. In 2015, when Mr. Jacobson was sentenced, it was illegal. That is what distinguishes this case from Clark, from Moore, from Murdoch. When the sentence was pronounced, the original sentence in 2015, it was illegal and all the parties agree.
What's your best case or argument for the proposition that a finding of illegality in part of a sentence renders the entire sentence illegal?
I mean, I guess it would be that the Court of Appeals vacated the entire sentence. I don't know that I have a good case side for that, but
Well,
they
I
didn't
think
say
the-
we're going to vacate part of the sentence and just remand for a little bit. We're vacating the whole thing. You have to start over.
Don't we have case law that suggests when part of a sentence has been found to be illegal, the lower court does not have discretion to alter the portions of the sentence that were not found to be illegal?
Candidly, Your Honor, I'm not sure.
If that was the
brief
case,
that.
would it cut against your argument?
I guess it might cut against my argument here, but again, the parties all agreed that this sentence was illegal in 2015. It
Well, they
all
agreed
needs to
that
be
part, they
vacated.
agreed, to be accurate, they agreed that part of the sentence was illegal, right?
Right, right. But then agreed that any other criminal history challenges could be raised in front of the district court. So in 2022, when he's resentenced and we re-raise these issues, wet trick is the law of the land.
And it does go to criminal history, which taints the entire sentence.
That's correct, Your Honor. There are no other questions. I will waive the rest of my time. Thank you.
Thank you. Mr. Obermeyer, you reserve 5 minutes.
Justice Standridge, I believe your question about whether or not this is pending a direct appeal, I think that that's probably the easiest way for this court to address this case. It's the state's position that this is not a direct appeal. Therefore, there is no change in the law which occurred.
Why does that matter? I mean, as I understand defendant's argument, their defendant's saying, look, he was sentenced in 2022, just apply 2022 law.
Well, because 2022 law is the court has to apply the law in effect at the time the defendant was originally
Well,
sentenced.
no, but that's exactly the point that I think the defendant is arguing, is that all went away. There is no quote unquote original sentencing date. He's only been sentenced one time, and that happened in 2022.
Well, the sentence that was pronounced in 2015 might have been illegal, but it nevertheless does function as a sentence for which he could have taken a direct appeal, but which he did not. And he might have received the benefit of wet trick had an appeal been taken there and it ultimately been decided at the same time. So I think that's the distinguishing factor. Procedurally,
That's fair.
Well,
I mean, really, if you're talking about the sentence being illegal at the time that it was first pronounced, okay. And nobody challenges it at the time. Then you come in with a motion for illegal sentence, and I get Clark, I mean, but, once it's illegal, why can't the defendant get the benefit of the change in the law, basically, that occurs where, I mean, in other words, had he appealed, done a direct appeal and gone up, he's going to get the benefit here. But because they didn't, and they waited for the motion to correct an illegal sentence, now that benefit has gone away. Just seems like we ought to figure out this. I mean, sentencing stuff makes my head explode anyway. But it just seems like we ought to be applying the same rules for everybody all the time. So again, how is it fair to look at the law the way you just tried to argue it?
well, Justice Biles, that is the process which it goes to. He received all procedural fairness. Even if he chose not to appeal, and that other defendants have received different results from their criminal sentences. That's just the unfortunate result, that some will receive a benefit and some won't. But it's fair.
Counsel, wouldn't it be true that if he did a direct appeal in 2015, that Vandervoort would be, Vandervoort was the law of the land until 2019. So if it would have happened in a direct appeal, then it would have been exactly the 2015, right?
Agreed.
So he wouldn't have gotten the benefit, correct?
I agree, Justice Standridge. And just to clarify, I was working under the presupposition that his appeal would somehow last until Wettrick applied, but I agree.
4 years?
We're
slow, not that slow.
I did not mean to impugn this court, Your Honor. I apologize.
I would just come back to this whole, did he appeal, didn't he appeal? It seems to me be missing, I guess, the point. I don't see why the question of the appeal is even relevant, because the fundamental question is, when was he sentenced? And I still haven't heard, like, what's your best argument to rebut the defendant's claim that he was sentenced in 2022? Based on the quirk of this case is that there was a finding of illegality that has nothing to do with the issues before the court, right? That finding of illegality is not contested.
Yes, that's correct, Justice Stiegel. I think that the best argument I have on that is that the Missouri convictions, those were legal when the sentence, as from the state's point of view, was pronounced, albeit illegal.
That criminal history was correct.
That criminal history was correct. So, and those convictions supporting that part of his sentence were and remain.
Wouldn't the sentence itself have been illegal, however, because it placed the defendant in the incorrect grid box?
Yes, it would have. It would have been in 2015 illegal, but not all the classifications. So that's the distinction.
But the entire sentence was illegal.
In terms of the sentence, yes, itself.
And that's the distinction from Clark, because in Clark, we said, wait a second, that original sentence in 2005, although in its winding way to us was at one point held to be illegal, we ultimately concluded that in 2005, it wasn't illegal. And that's the critical distinction between this case and Clark, right?
That is, but I think that Clark also, procedurally, he was in a stronger position to assert he was entitled to the benefit of the law, a change in the law brought by Wettrick, because as I read his case, he was sentenced in 2005. He filed a motion to correct an illegal sentence in 2017. The Court of Appeals reversed based on Wettrick. He was resentenced in 2019, and then this court held clearly from that Wettrick did not apply. So procedurally, I'm not sure.
Well, that's because the resentencing in 2019 was wrong.
And the state's position would be that the resentencing or the reclassifications would be wrong as well, which is that goes to the resentencing.
When is the resentencing date that is advocated by the defendant here as the pinpoint for the actual date of sentencing?
In 2022, when he received.
So
sentence.
then the municipal convictions are back in play? Is that how that would play out? Because that law has changed.
That was not briefed by the
I
party.
understand, but let's just say hypothetically, if a defendant in that position, then if you're going to, take that view, then you're going to have to take the good with the bad,
That's
theoretically.
That certainly is a potential consequence, yes.
And so then, just jumping off where Justice Wall says, then if another motion to correct the legal sentence is filed, in this case, hypothetically, then it would be even more different. If there's a change in the law, this could go on forever, right? Because every time there's a new sentencing date, it's all going to depend on what the new law is, and it just ad infinitum.
And that's what I think the court was trying to do with Clark, is to put a definite date where Wettrick is effective from the date it's decided until the date it's legislatively overruled or subsequent court rulings state that. Unless there are any further questions. Madam Chief Justice, may I briefly close?
Yes, you may.
It would ask that the court affirm the decision of the district court denying the defendant's motion to classify his Missouri attempted robbery convictions as non-person felonies. The proper standard in this case is the standard of Vandervoort, which was the controlling law when the sentence was originally pronounced in 2015. We ask the court reverse the Court of Appeals and affirm the district court. Thank you.
Thank you. Thank you to both counsel for your arguments in this matter. The court will take this matter under advisement. I might let you know that what that means is that later today, the court will begin to conference this case and the other cases we hear today. We will perhaps by the end of the day, perhaps not, but at some point, we will through those conversations with each other, determine the outcome of the appeal and the path that we for the reasoning that gets us to that outcome. And I said that poorly because I want to emphasize that we figure out the reasoning before we figure out the outcome, because we don't determine, we don't change our reasoning to fit an outcome. We use the reasoning to get to an outcome. So anyway, with that clarification, we will have one justice assigned to write the decision. That justice will then circulate a draft opinion to the other 6 of us. We then all review that, make our comments, our edits, suggested edits to it. We may all agree, in which case that will be the only decision. It may be that we do disagree in some way, and there are 2 ways that could happen. One is that we could agree with the outcome that the Court of Appeals should or should not be affirmed. We may agree on that, but we may have different reasons for that. In that case, one or more of us might write a concurring opinion. But it could also be that we disagree about that ultimate outcome. And in that case, one or more of us could write dissenting opinions. Once those opinions are all finalized, they're filed with Mr. Shima's office, the clerk of the court. They are also posted on the kscourts.org website. We do release a press release so that you can know that those decisions have been filed and they are out there. At that time, you'll be able to read the outcome of what of the case that you heard today. Thank you, counsel. One for State of Kansas versus Joshua Evan Stows. Well, as you're settling in, I would like to express the court's appreciation for your flexibility, and we did change the time of this argument from 10:30 to 9 o'clock this morning, and council were very accommodating in that. We appreciate that. Thank you.
That's no problem, Your Honor. As someone who's finishing up paternity leave, this gets me out on the disc golf course a little bit earlier even, so. May it please the court? Police stopped Joshua Stows for walking down the wrong side of the road. When asked his name, Mr. Stows told the officers his name was Joshua Greenmore and produced a social security card for Mr. Greenmore. Not believing Mr. Stows to be Mr. Greenmore, officers arrested Mr. Stows with the intent to book him into jail as a John Doe, but Mr. Stows revealed his identity at the jail. Mr. Stows was indicted on one count of identity theft, the state's theory being Mr. Stows used Mr. Greenmore's personal identifying information in an attempt to attain the benefit of not being arrested on outstanding warrants. Mr. Stowe's theory of the case is that he did not intend to defraud Mr. Greenmore or anyone, and that he only committed, that he did not commit identity theft, but committed interference with a law enforcement officer. Pursuant to 21-5109D, Mr. Stows could only be sentenced to the more specific crime, interference, and the Court of Appeals erred in finding otherwise.
How does he get sentenced to a crime that wasn't even charged or convicted on? How would that work?
Correct. So when we look to the past cases that the legislature modeled 21-5109D on, particularly Williams, what happens is once the defendant brings this up to the district court's attention, it is on the district court to determine what is the more specific crime. And in particularly here, even though his conviction was for interference, after all the evidence is in, the district court is in a position to say, no, the specific crime here is interference, and sentence them to the terms of that crime.
So the district court has an obligation to amend the complaint and add a charge?
Or dismiss the complaint, as what happened in Williams and in I believe in Williams, in Williams that occurred, that also, I'm blanking on my other cases, but we also see this in Marlon Williams when we discuss this. Reed and Wilcox, they also discuss, because when the rule is discussed by this court in pre-Euler, and at the time it's being modeled, 21-5109 is being modeled off of, the general specific was spoke of as a charging rule. You know, that the state can't charge this, that the defendant can charge this. Now, it has been reached for the first time on appeal, but the fact of the matter is when Mr. Stows informed the district court, no, this is not interference, I am guilty, or excuse me, this is not identity theft, I'm guilty of interference of a law enforcement officer, that put the ball in the district court's position to make sure that the more specific crime was in front of the jury as the legislature and the statute require.
So in your view, it raises no due process concerns, or is it more accurate to say that there's a waiver essentially of any due process concerns because your client wants the more favorable sentence?
The due process is tricky because I understand that there is a sword could cut both sides on this one, to where a person could get convicted of a lower penalty, more general crime, but then later on at sentencing state could be like, well, hey, this is more serious crime. I think that would provide a due process problem because the defendant is the one that has to be on notice of what they're defending against and what they're facing. But one, the due process doesn't cut towards the state. And two, the state, as the person in charge of the charging, ought to be responsible for picking the most specific, most appropriate crime to begin with. But if they don't, this is an opportunity for the defendant to get that most specific crime in front of the jury and to fulfill the legislative intent of 21-5109D.
On that
Go ahead.
on that statute, how would you articulate fitting these two crimes into that statute you just referenced, the statutory definition of general and specific crimes?
Yes. So when we look to general specific, because remember, When the legislature codified the general specific, the note from the codification committee was that they were attempting to comment, talking a little bit faster, I'm gonna slow down here, that they were attempting to codify this court's precedent as stated in Williams.
Well, I don't want to focus on that. I just want to look at the statutory language, and what I'm looking at is that what the legislature said is that general and specific are crimes that differ when one is defined to prohibited a designated kind of conduct generally, and the other defined to prohibit a specific instance of such conduct. So it seemed to me that you would have to say that identity theft or is what? That's somehow interference with a law enforcement officer is like, I just don't
Yeah.
see the
And
connection.
I understand, but I think the key word there is the conduct, because when we look at other cases, when we looked at Marlon Williams, now there are two Williams in these cases, which is confusing, but the 2014 Williams, Marlon Williams. Now there, the general specific test was negated because this court found he was actually charged with a specific crime, and the crime that he was complaining he should have been charged with wouldn't have captured the full gravitas and the full actions of what he did. So we focus on the conduct of the defendant. Now, if we're focusing on the strict elements test and one crime is always going to be the other, then we're in identical offense territory. But when we focus on the conduct of the defendant and we look at Mr. Stowe's conduct here, his conduct was using personal identifying information, which fits the category of any false information, but the specific benefit, because identity theft is for any benefit under the sun, anything you can think of, whereas interference is a very specific benefit to impede the duty of the officer. So here, when we have a category of information.
So
that fits-
interference with a law enforcement officer is the only reason the legislature passed that is to prohibit a specific instance of identity theft. I don't
think-
understand that.
No, that when somebody gives false information to police to avoid arrest, that is interference, regardless of whether or not the information given is personal identifying.
I understand that argument, but I just want, maybe we're talking past each other. I just couldn't conceptualize how that fits the statutory definition.
Again, I think because once we're looking at the conduct, which is why we need to know the facts of what's going on, you can't necessarily do this from the complaint. You have to know the underlying facts so you can say which crime is more
Well, the
specific to the conduct.
this will be the last question I'll ask, but the statute says that the specific crime is defined as prohibiting a specific instance of such conduct. And the such conduct we're talking about here is identity theft. So that it just strikes me that your argument has to be interference with a law enforcement officer is a specific kind of identity theft.
I think that once somebody gives information to a law enforcement officer to receive the benefit of not getting, basically anytime you give a false name to the police, you are committing interference. Now, the only difference between interference and identity theft in that case is whether or not the name turns out to be real. And in fact, so let's say I get pulled over by the police. I have a warrant out, which I do not, and I would not be here if that were the case. But let's say I get pulled over and I don't want to go to jail. So I think of the most generic name I can think of off the top of my head. And I say Will Smith. Well, the famous rapper, actor, probably not going to be too happy about that. And the fact of the matter is that even though I was intending to create interference, I did not want to defraud anybody, didn't want to take Will Smith. The fact that I just made up a name and it turned out to be a real name isn't even a defense to interference. So we're getting to this place to where the only difference between interference of a law enforcement officer for giving a wrong name and identity theft is whether or not the name corresponds to a real person, regardless of whether you even knew that or not.
Here, there's an additional fact that he handed a social security card, and doesn't that make a difference in the conduct in satisfying the identity theft? That's a difference here between your scenario of just throwing out a name.
Sure, but I also think that that's a little bit of a red herring because one, whether or not he had the social security card, he's still just as guilty of identity theft because using a name or even a place of employment or even a screen name is enough for identity theft. So even if he did not have the social security card, this identity theft is still there. And on top of that, the gravamen of identity theft isn't the possessing or the using of the personal identifying information. It's for the personal benefit. And any benefit is an incredibly broad category, but the gravamen here, the exact benefit is a very specific type of benefit to impede the arrest. So in that case, yeah, this is clearly the more specific because the benefit is what we're looking at here. And the information can fit both categories, but the specific, the benefit, and again, without any intent to get a benefit, there is no identity theft. I can carry on someone,
It seems that you're slipping from conduct to something other than conduct when you talk about the benefit. And you've been arguing that what we need to focus on is the conduct. Do you understand what I'm saying? I mean, to me, it seems
yeah.
like the language of the statute is more like, I commit identity theft, and there's this generic statute about identity theft. But then there's another statute about identity theft when I use a passport. And that is a more specific conduct than the more general, I can commit identity theft in a multitude of ways.
Sure, and I understand that those are the easier cases, you know, I mean, those are the very clear cases, but I think what the legislature is trying to do by going back to Williams is to make sure that the state is charging the most specific, most appropriate crime.
So get us to Williams.
Yes,
We don't get to Williams unless we find that statute to be ambiguous. Correct?
no, well, it depends, because I understand, you know, the general way this court seems to do statutory interpretation is we start with the plain language, and then if we can find an answer from the plain language, we're done. Now, but I think the problem is that if we're consulting the plain language when we know what the legislative intent is and the legislative intent to codify Williams, we can't look to the plain language while ignoring that legislative intent because
We've got several cases that say we can.
again,
Because it's so hard to, you know, the words are the words.
the words are the words, but when we have the legislature saying, hey, we want to codify this case law and we're using these words to do it, I think the legislature is telling us what they meant to say. And as interpreters of legislative intent, we can't turn a blind eye to that because then that's just essentially overruling what the legislature tried to do. So when we don't know what the legislature is trying to do and we have sketchy legislative intent or we don't know, then obviously the plain language, but we are here to interpret the laws that the legislature made as they intended to make them. And so if we know what the legislature tried to intend, I think we have to read the plain language with that in mind, or else we're just running roughshod over the legislature.
And is your plain language, I'm getting a little bit mixed up, but is your plain language saying that once a defendant brings up a more specific crime, the court has the duty to make sure the specific crime is in front of the jury?
I think if you get the chance before, then yes, but also, so going to the plain language of 2159 OD, we got an A and a B. I read those as setting out two separate rules, one as a rule to prevent somebody from being convicted of a more general crime in lieu of the specific. And the second one, that in case that happens, the defendant can still make the showing or bring it to the attention of the court, because it doesn't say the conviction, it says that you are sentenced to according to the terms of the more specific crime.
I see. I mean, I understand all your arguments, and I understand that if both of these were charged, where I'm hung up is how do we even get there? Because the statute is, I mean, we've got a separation of powers issue here. The statute gives the prosecutor prosecutorial discretion. The defendant may be prosecuted. That's under 2150-109A. The defendant may be prosecuted for each of such crimes. This is not a court decision. The court doesn't decide what statutes are being prosecuted. And I don't see from the plain language of this statute, I don't see any ambiguity here saying, I mean, it does not give the court any authority or duty or anything to make any kind of.
But this is where we have to look at what the legislature did and when they cited to Williams in passing this, because sure, 2150-109A.
Where in here are we even, as the chief said, where in here are we even going to what the legislature cited in Williams? I mean, it's clear here that this is, you can't be, the whole point of this is, if you're charged with two, you got to be, sentenced to the lesser. Where does it talk about, and if you're only charged with one, and a defendant brings up another, then the court has the duty to make the more specific crime in front of the jury.
Because we see this in Williams itself, because in Williams, the defendant was only charged with one crime. He filed a motion to dismiss. The court, the district court said, yes, the crime that you are not charged with is the more specific. Your aggravated indecent liberties with a child is dismissed because aggravated incest is the most common. So when
The procedural history here was there a motion to dismiss filed?
Mr. Stowe's was charged via indictment, so he didn't get a preliminary hearing to see the evidence before. But at jury trial, he requested for the court to tell the jury that he was guilty of interference with a law enforcement officer and not interference. And then at sentencing, when the second part could have kicked in, Mr. Stowe's himself said, I did not try to impede, I did not try to defraud anybody. I didn't try to steal information, but I probably did impede. So the district court had the information. And when we look to, this is why we have to take the legislative intent into effect, because this subsection 215109D was meant to codify the procedure and the law as stated in Williams. Williams is only charged with one crime, which allowed this to happen. So we have to look at in that route. And as far as 215109A, 215109A sets out a general rule, but B, C, D, and E limit that general rule and provide exceptions to the prosecutorial discretion. But at the end of the day, the legislature was trying to ensure that people were charged with the most specific, most appropriate crime and not novel applications or, suspect applications of different general crimes.
I think the key there is you say are not being charged because the charging is in A, but everything else is convicted.
Right, which means the defendant can bring this problem before the conviction or under B, even afterwards, after the evidence is in, and say, hey, look, this evidence satisfies the more specific crime. I can only be sentenced according to the terms of that crime.
Right, and maybe a judgment for acquittal at the,
We had judgment for acquittal, it got denied. And that's that's the problem with specific general, right? I can't deny that there's sufficient evidence for identity theft because the benefit is so much broader. It's when we look to what the actual statute is trying to prohibit, which in this case, interference is impeding of the duty. That's where the problems come. That's why you can't really raise a sufficiency issue to these things because they fit, because one is more general and it's like a funnel. I'm trying to argue that we should be sentenced down here. Well, naturally, everything else is gonna fit when we go up the funnel, correct?
I want to return to our discussion about conduct versus mens rea, because I think what you're focused on is mens rea, not conduct. If you look at the two statutes, the identity theft is obtaining, possessing, transfer, using, selling, and purchasing identifying information. It has nothing to do about a false report to a law enforcement officer, which is the conduct that's involved with interference with a law enforcement officer. And so if we focus on conduct, as you argue, is the focus of the statute, there's no overlap there. You get to the overlap, as I understand it, by arguing where the intent was on the mens rea, but that's different than conduct.
Well, no. No, excuse me. So the way I look at this is that yes, the subsection A of identity theft says that identity theft is doing these things with the personal identifying information, right? But having this information alone isn't enough. It's what you do with it. So if I was walking around with somebody else's social security card or even just trying to return it to them.
No, it's obtaining.
Yes.
What your client did, possessing what your client did. And then, there are other things which include using.
Sure.
But I don't remember that the charging document was specific to, the laundry list.
Right, but I will say this. One, we don't know that Mr. Stowe's obtained the document with intent to defraud. He had it, but we don't know why he got it or how he got it. We don't know why he was possessing it.
That's sufficient, but to your point, that's sufficient.
Sure, I know, but the only thing that works, that they proved is using. And using that information when you give to a law enforcement officer is giving false information to law enforcement. It's the same. So the conduct is the same, but what makes the crimes, what makes these actions crimes is the intent. Now, an identity theft, so the way I look at this is that you have an identity theft, you have a narrower universe of information, right? Now, the information itself is not the crime. It's what you do with that information. Now, again, the same thing with interference, except you have a much larger universe of information, any information, right?
Couldn't under your theory of this case, had Mr. Stoles pulled out a gun and shot the arresting officer, you could come argue, oh, more specific, he interfered with duty of a law enforcement. Like, how is that any different?
No,
Or
I mean, I
your
think-
theory of the case.
I mean, I think in that crime, the more specific case or crime would obviously be, you know, battery on a Leo, ag battery on a Leo.
Why is that obvious?
Because he didn't give any information when he shot him. He gave him a bullet, but he didn't give any information to impede the arrest. He just shot him and ran.
I just think the argument that you're making here could be made equally with those two different statutes.
I mean, unless,
Because let's say it's battery or whatever, like that's a broad, you can batter a person in a lot of different ways. But it's more specific if you batter a law enforcement officer in order to avoid arrest.
right. No, exactly. And in that case, if you're charged with normal battery, that would be the
So you
incorrect.
do think it would apply in a battery situation?
If we're dealing with battery and battery with Leo, but here, again, I think if I can finish my point about the broad narrow. So with the identity theft, we have narrow information, but then we go into this broad any benefit, right? Now, again, the information isn't criminal itself. Now, interference with the Leo, reporting any information broad, but reporting any information isn't the crime itself. It's the purpose you do it for. So in interference, in identity theft, we have very narrow information, way up any benefit, right? Now, interference, we have any information, impede arrest. Now, when the information fits into both categories, and neither one of those is criminal on its own, you have to look at what you do with the information, and interference in this situation is clearly the more specific crime.
One last question from me anyway. As I reviewed this, I noticed that, well, let me start with this. My understanding is your request is that your client be resentenced to, interference.
The way, I understand the case law, I think that's the proper remedy. You know, as I was getting ready for this argument, part of me is wondering if I asked for the wrong remedy. I don't know if the answer should just be to vacate his interference. But the way I read the statutes, I think the proper remedy would have been for him to only serve the term for the more specific crime.
And as I looked through things, I noticed that he was sentenced in August of 2021 to 18 months.
Right.
So that's since.
No, yeah, that sentence
long
has been long
gone.
served, yes.
So is this moot?
It is, it may be moot as it relates to Mr. Stowe's sentence, but as a matter capable of repetition and able to avoid review, because remember, identity theft's only a level 8 and interference is only a level 9 at worst, if not a misdemeanor. I don't think this court, if we have this interplay again, would really get a chance to look at this problem, given those sentences.
Will it affect his criminal history score?
If his, I would have to look. I don't believe so, because I believe he was a criminal history A, but I have sentencing at council table, and I can check that out and answer
But I
that.
mean, in future cases.
No, I believe he's already in A. Yeah, so it should not.
Plus, as I understand, you're not asking for a new conviction. You're just asking for a different sentence.
At the time we were, but you know, as time goes on, it's tough to switch remedy midstream in an appeal. But I do think that this court, particularly in light of Euler, I think that clarification is needed on this statute. And so that regardless of whether or not this has any impact on Mr. Stowe's personally, I think that it does meet an exception to mootness as capable of repetition and question that needs to be answered by this court. I have no more presentation. I'm more than happy to answer any questions. But if not, I will sit down and turn the lectern over to my colleague. Thank you.
Good morning, may it please the court. The state appears by Deputy District Attorney. The state's position here, as I think the court has already hit on, is that, well, the Court of Appeals got it right, and that this statute doesn't even apply when the state charges one count of something and not two. When we don't have two convictions under the plain language of the statute, this doesn't apply.
And what language are you focused on when you say that? Is it the may not be convicted of the two crimes in one, in some part one, D1?
Yes. Yes, Your Honor.
And you think that carries on to D2?
Yes, I think it's, well, there's an and there.
There
So
is an and there.
we have to have whatever's in subsection 1 to get the sentencing relief. So, and the state didn't even brief whether you can get sentencing relief on something that you weren't charged for, which I don't know that you can. If you're not charged and convicted, I don't know that you can get a sentence for a different crime, but we didn't brief that. But yes, our point would be the legislature very specifically said may not be convicted of the two crimes based upon the same conduct. And then there's that and. So when we don't have two crimes that were convicted of, that the defendant was convicted of, this doesn't even apply. And I think that that kind of goes along with the prosecutorial discretion that we've been talking about. There are other subsections of that statute which limit prosecutorial discretion, just like this one does. And we can charge multiple crimes. We just can't convict and sentence on them both. That's when it becomes the problem, like in multiplicity.
But it seems strange then that you'd have that statutory scheme, yet you could avoid it all just by charging the more general offense. You know what I mean? It's like, it seems to me that the legislature's really directing that the discretion be towards the more specific offense. It should be the charge and the sentence. But it sounds to me like your interpretation would allow a prosecutor to sort of avoid that all and just by charging one offense and choosing the more general offense.
I would agree with that. I mean, I think there's no limitation on if there are a set of facts that apply. I think this court has said when there are two statutes that it applies to, that the state can do that, and we have discretion to do that.
Except when it goes on in the statute to really direct that a preference towards a specific crime be charged and convicted in the exercise of that discretion. Why couldn't the statute be read that way? I guess
I guess the
as
state
a limitation on charging discretion.
I guess the state doesn't read charging in that because the legislature, I mean, because the language of the statute says convicted. And they could have easily just put may not be charged or convicted.
It
And we
does
don't
say
have that here.
shall be sentenced. Admittedly is not directed at the prosecutor. Shall be sentenced according to the terms of the more specific crime.
Yes, which doesn't trigger until we have the convictions for both.
Oh, but where do you get that from the language? That there's two convictions,
May not be convicted of the two crimes.
right? And then it says shall be sentenced according to the terms of the more specific. So you think reading those two together, I guess your argument is that this only applies if there's two convictions.
Yes. And if we look at some of the other case law, I think there's a couple of opinions by the Court of Appeals. I think they're unpublished, but since this statute has been enacted, I think the majority of cases have dealt with situations where the state has charged identity theft and criminal use of a financial card or child abuse and aggravated battery. And they've had similar challenges to this. And the Court of Appeals, I think the defendant got relief on the identity theft and criminal use of a financial card, saying that criminal use of a financial card is the more specific offense. So you can't be sentenced on both and when you're convicted on both crimes. So I think there have been appellate court decisions that have dealt with two charges, two convictions, and then deciding whether it's general versus specific.
I assume you think we don't need to decide necessarily that issue, do we, to resolve this appeal? If if identity theft is not fit within the more specific subsection D of that statute, right?
If
We don't have to decide whether this applies only to two when there are two charges. If we go ahead and find and we can determine on the merits that interference with law enforcement officer doesn't fit into subsection D.
I think this court could avoid the question, of what triggers the rule and just find that, and we did argue, and that's what I argued in the brief, is that interference is not the more specific. So I suppose this court could, but it is an issue that the court has avoided in other cases, so it might be nice to have some guidance on when that rule is triggered. But yeah, I suppose this court.
What
could
would have
decide.
happened if you had charged both crimes, interference and identity theft? Would we still have two separate sentencings?
If we would have charged both and convicted on both, I think he
Right.
could have made this argument and then the court, this rule would be triggered because we have two convictions for the same crime based upon, or I'm sorry, two convictions, convicted of two crimes based upon the same conduct. And then the court can get into the general versus specific analysis. And if this court found that interference was the more specific crime, then he would get relief. But again, we just argue that this is not the more specific crime. And as we laid out in our brief,
Well, if
we
it's
don't-
not the more specific crime, then why? Just what you said, why couldn't he be sentenced for both? It doesn't fit in the
I
statute.
think he could, I mean,
I thought you just said no, then they're kicking the analysis. It just seems to me your position is there are two separate crimes. He could be sentenced, he could be charged, convicted, and sentenced on both separately. Is that your position?
yes, because, well, then that kind of goes up to the top part. When crimes differ only in that one is defined to prohibit a designated kind of conduct generally, and the other to prohibit a specific instance of such conduct. So if this court found, no, there's no general versus specific, these are two different
Right, that-
statutes, yes, then he can be sentenced on both.
Thank you.
Let me ask you a question. There's prosecutorial discretion, obviously built into the statute, but have we crossed into, arbitrary enforcement, with the charging documents? Let's say from, I mean, really, there doesn't seem to be any right, I mean, assuming how you answered Justice Rosen's question, assuming we disagree with that he couldn't have been convicted and sentenced to both because it's the same underlying conduct. I mean, how do we deal with a prosecutor that always overcharges in one instance and then a prosecutor who doesn't in another instance?
I mean, I think there are, as set out in 215109, there are, limits to prosecutorial discretion. And if, two statutes fit, if facts fit two statutes and the state believes that they can meet its burden to prove beyond a reasonable doubt, I think the prosecution has that discretion.
I don't
I don't
think
know
that-
that it's the court's job to come in and determine what the state can and can't charge.
Well, there's no limit on the prosecutor in 5109, right?
Well, it sets out certain things that the prosecution can't do, certainly. I mean, defendant
What?
defendant cannot, I think it's E, you can't be convicted of both a greater
not-
and a lesser.
Right, well, that's not something on the prosecutor. That's just saying that the jury or the court can't convict.
Well, I suppose they could charge them with both.
Right,
So that doesn't limit their charging ability, but they
Right.
can't be sentenced.
right.
Oh.
So, that's not a limit on the prosecutor. There's no limits on.
I mean, I guess I would just go with, I think there's case law that says that there's the prosecutorial discretion that the state has is not to be, I don't know the right word for it, but I don't know that this court's has authority to question that.
Would you agree, going back to Justice Paul's earlier question, that effectively eviscerates subsection D? I mean, as soon as this court pronounces a ruling that one crime is a more specific instance of a second crime, like the memo goes out to prosecutors across the state, don't charge these together. Only charge the more general crime, never charge the specific, right? And there'll be nothing wrong with that.
I mean, yeah, I think possibly in that Court of Appeals case where they said, hey, you can't be convicted of identity theft and criminal use of a financial card. Look at your facts and see which one, if it covers both, then you have to be charged. I think the prosecution would charge them with the more specific
Why?
offense.
Why would the prosecutor ever do that? I don't understand that.
Charge them with the more specific offense for the facts that, I mean,
Doesn't the prosecutor want to? I'm not attempting to malign prosecutors here, but just from the perspective of you want the strongest case you can bring. And if the law permits you to seek conviction under the general crime, so long as you don't charge the specific crime, why wouldn't you do that?
I suppose we can.
So it does eviscerate
I mean,
subsection D.
I don't know that it eviscerates subsection D because subsection D has that specific language of it cannot be convicted of the two crimes. So,
Or
I mean,
sentence.
may, but it may not. I mean, it's just a may not in that use of may in that one and shall into is interesting, I guess.
So the second
basically.
crime-
So,
Second crime may merge with the first crime, or if there are two convictions and you can only have one sentence, then you have to do something with that second conviction. It may go away, it may be reversed, it may be merged, but the sentence has to be of the lesser.
Well, the sentence has to be of the more specific crime. That doesn't necessarily mean it's a lesser
Or
punishment.
more specific, true.
Yeah, so I mean,
Could be a lesser.
the more specific crime could have a greater punishment. So I don't know that, yeah, I mean, I don't know what happens to the other conviction. What the Court of Appeals did in that case or what the district court does when they find that one's more specific than the other. But certainly they can't be sentenced. Well, they can't be sentenced according to the terms of the more general crime. They have to be sentenced to the more specific. I don't know that I have any further presentation for the court.
questions. Do you have a position on my question about whether this is moot?
You know, Your Honor, I didn't file a notice of change in custodial status. I'm not sure when I know he was released, but I'm not sure when that lined up with when the case was docketed. But since this was framed as a sentencing issue, I think this court could find it moot since he has served his sentence, although I'm not sure about post-release time, if that counts.
I think that's important too.
So, and I didn't look up whether he was still on post-release, but I do believe he is no longer serving the prison portion of the sentence.
Thank you, Your Honors. And a shocking twist, I actually don't have anything else to say, unless this court has any questions. I would just ask that this court reverse the Court of Appeals, and thank you very much. Appreciate it.
Court will take this matter under advisement. The court will now be in recess until 10:35. All right.